It has never ruled on rules like this. In Citizens United, in McCutcheon, it is ruling against a background of existing disclosure rules. And as I mentioned in my prepared testimony, we have more disclosure now than at any time in American history. And the court has looked at that and said, this is the solution. This is adequate. It should not be read to suggest that the court is saying, go ahead and do whatever things more you want to do.
Well, what is so wrong with disclosing the people that give these kinds of countries?
Well, the question again...
Why would that make it different than the other rules?
The question is who or what is going to be disclosed. For example, this act does not require disclosure by the American Constitution Society of its donors. Maybe it should. The American Constitution Society would escape it because it's a C3. It doesn't engage in a certain type of political activity. But anybody who says that it's not out there trying to influence politics is not serious. I mean, that's what a lot of groups do. So again, the question is not that people are opposed to disclosure as if this is some clear, obvious thing. The question is what should be disclosed, right? When and how, and to what extent do we want to tie our system up trying to get, the last little bit of disclosure out of the system. 501c4s have long done very, very hard-hitting issue ads. The NAACP ran ads in 2000 that reenacted the lynching of a man named James Byrd, and the narrator specifically blamed it on then Governor George W. Bush. It ran these ads in October, just before the election. They didn't disclose their donors. Nobody got upset about it at the time. This is not something new in that respect. It's not new since Citizens United. It's only been viewed as a crisis, so to speak, since Citizens United. And I think that really is a reaction to Citizens United rather than a serious, reevaluation of the need for added disclosure in this area. So, again, my organization and I have supported disclosure. I've supported it in my academic writings, but it's a question of what should be disclosed and how much. The Supreme Court has not endorsed all disclosure. In many cases, in the 70s, 80s, 90s, and 2000s, it has protected the right of citizens to engage in political activity anonymously, and nothing in Citizens United or McCutcheon overrules any of those decisions.